Good afternoon, everybody. My name is Adam Gislason of the Lohman Abdo Law Firm, and you've joined us today for a CLE called Cases of Beer, Recent Intellectual Property and Litigation Developments in the Craft Beer and Distillery Industries. We had discussed calling today's CLE Free Beer, but I'm not quite sure that would have gotten the response that we were hoping if this would be a live audience as opposed to a webcast, although we do have some people here. We do have beer in the refrigerator, and we plan to drink it after the webcast. So we're going to take some questions and answers later today, but if you're sitting there enjoying today's CLE with a beer in hand, we hope you're drinking Lithbridge beer. We've got a fantastic panel here today. To my left is Jeff O'Brien. He's also with the Lohman Abdo Law Firm. Jeff is going to tell you all about his exciting practice. We also have Dan Schwarz with us today. He is the CEO of Lithbridge, and he's also the president of the Minnesota Craft Brewers Guild. And at the end of the table is the distinguished Christie Healey, who is also with the Lohman Abdo Law Firm in our Business Affairs office. So if you could, Jeff, why don't you describe your practice and why it's so exciting today?
Well, I'm the quota today. I'm the non-trademark attorney. I work with a lot of breweries, distilleries, and wineries in Minnesota and in other states. And so I work with everything with business formation, the real estate issues, fundraising, licensing. But as we're going to find out today, you have to have at least a working knowledge of trademark law to be able to adequately represent your clients in this industry.
Right, but in addition to intellectual property issues, there's a whole host of legal issues that concern craft brewers and the formation of those breweries here in Minnesota and around the nation. And Jeff is one of the leading experts in the field, so we're happy to have him here. Dan, let's give a little bit of background, a little bit more background about your story and Lithbridge.
Sure. So Lithbridge was founded in 2008. Founded it with 4 other friends and neighbors, and we're based in Stillwater, Minnesota. And currently we're in the top 10 largest breweries in the state, and we've been brewing beer, as I mentioned, since 2008, and we've incorporated intellectual property and trademark into our business plan. I currently serve as the president of the Minnesota Craft Brewers Guild, and we represent 74 breweries in Minnesota. Happy to say that 50 of those breweries were formed in the last 5 years, so there's been tremendous growth recently, and actually has created a little bit of a challenge for breweries when it comes to naming, and I think this underscores why it's so important to get your trademark strategy in place.
And when did you become president of the Craft Brewers Guild?
I became president in January of 2010, and this is my second year as president.
Congratulations.
Thanks.
And Christie, how are you?
I'm very well today,
Let's hear more about you.
Well, I spent my formative years, many of them, in working for the studios in Hollywood and dealing with major motion pictures, and then I got interested in working with independent filmmakers, and that led me to specialize in intellectual property because, of course, it's the basis of everything and why everybody earns so much money eventually in any business. And so that led me to Minnesota, not a strange place to come for a motion picture business affairs executive, because it's the home of independence. And so we now have a wonderful world of independence here in music, film, television, and beer.
Well, I am Adam Gislason, and I am a recent hire at Lohman Abdo. Prior to working at Lohman Abdo, I was at my own firm, Snyder, Gislason, Frazier, and prior to that at a much larger firm. My background is music and intellectual property, and missing from our panel today is Tim Mattson, who is one of our foremost trademark attorneys. So we've got a great group at Lohman Abdo that handle a variety of intellectual property issues, from not only the transactional aspect of it, but also the litigation aspect of it. So let's talk about what we're talking about. And as everyone knows, or as hopefully all that's joining the webcast knows, there's been an exponential growth in the Minnesota craft beer and distillery industries, and there's been an exponential growth nationwide. Mr. Schwarz mentioned the Craft Brewers Guild. I've had an opportunity to look at the 2015 Brewcation Destinations brochure, which is very helpful. I could open it up and share with you a map that plots out all the membership breweries in Minnesota. But Dan, you had mentioned how many members are there?
We have 74 breweries, and they really are all over the state. We looked around, so there's obviously a concentration in many of the metro areas, but really every corner of the state, and they're finding their own little craft brewery in their hometown.
And how many breweries are there in Minnesota? There may not be a member of the guild, but how many are there that you're aware of?
Pretty much every brewery is a member. There may be a few here and there who haven't joined or are in the process of it, but for the most part, we're pretty inclusive of everybody.
And what's the benefit of being a member of the guild?
Well, the guild was established to really help raise awareness about Minnesota craft beer and promote the industry. For a long time, as I mentioned, there were very few breweries. When we started in 2008, there were only about 17 breweries in the state. And compare that to, like I said, 74 today. Colorado has over 150 breweries in their state. I think San Diego has 50 in the city of San Diego alone. So Minnesota's a little bit behind the curve when it comes to craft breweries, but recently there's been this explosion, which has helped us to catch up a little bit.
And Jeff, you've been working with members of the guild for several years now. What's your perception of the guild and the increase in membership, and how that's kind of affecting some of the hot topic issues today?
Well, Adam, one of the things that I've been struck by in this industry is, you'd think with competitors, there would be a little bit more, usually there's a competitive edge, streak with everybody. The guild, the members of the guild and the breweries here, it's very collegial. You hear stories all the time about somebody's equipment breaks down and they're on the phone and somebody else is out looking to see if they have the part or coming over, and there's been this long history in this state of the breweries, the members of the guild are not working against each other. This is part of a movement, this whole craft movement, as opposed to some of the macro-produced, beers that we all know. So that's what's really, I think, the importance of the guild. I think the guild just strengthens and foments that collegiality that's really pervasive here.
And I don't want to leave out other members of other industries, and that would include the distillery industry, which there's now a boom in craft distilleries here in Minnesota, including 11 Wells, whom we've worked with. If you could just comment real quickly on the distillery industry and how that's expanding.
It's interesting. The distillery industry, you can track the growth of the distillery industry with the exponential growth in the craft beer industry here in the state. And it all leads back to a law that was passed a few years ago called the taproom law, also known as the Surly law, which allowed a production brewery to have a tap room and be able to sell pints. Previously, a brewery like Lithbridge, you could go there, you could take a tour, you could buy a growler, and you could sample the beer, but you couldn't go out, sit down, buy a pint or a flight, maybe have a food truck pull up and sit there and have an enjoyable evening. And you can do that after the taproom law. Inside of that taproom law, they reduced the licensing fee for distilleries exponentially. And so at the same time that the breweries, this new model of the brewery came out, where you may have growlers, some bottles on site, and tap room only, maybe not necessarily kegs right to start out with, maybe not necessarily being in liquor stores. At the same time, it became, the cost barriers to starting a distillery were removed, and now that's what you've seen, the growth with 11 Wells, with the Panther in Alexander, with Vickery in Duluth, with Du Nord, Norseman, all these that are out there that are coming up all relate back to the same legislation that opened the door for further growth in the craft beer industry.
Well, with explosive expansion comes explosive competition in the marketplace. And this can and has led to unfair competition and litigation. It's just topics that we're going to be discussing today. And recently there's been a boom in craft breweries, not only in Minnesota but around the nation, their efforts to register and protect their trademarks. Some would say that this is spiraling out of control. In January of this past year, some of you may have read or seen the article that was published on NPR called "Craft Brewers Are Running Out of Names and Into Legal Spats." If you haven't read that, check that out. Do a search for it. It's a nice little article that kind of frames this entire issue. So we get to the question, what's in a name? And with more than 3,000 craft breweries nationwide, the problem has become, the problem of protecting your mark and your name has become somewhat of an epidemic. This problem is also confounded by the USPTO, that's the United States Patent and Trademark Office, and trademark law, which lumps breweries and beer together with wine and wineries and booze and distilleries. So, as Shakespeare once said, what's in a name? For breweries like Lithbridge, it may be all or nothing. And if you could, Dan, let's just talk about how you chose the name Lithbridge and how you go about choosing some of the brand names for your brews.
Sure. What we did first is when we started the business, we talked about what are kind of, who is our brewery going to be? What are our values? What's our mission going to be? And once we kind of defined those, then we started talking about names and brands and styles of beer that would help reflect that and represent us. So really, I think it comes back to kind of your core and your mission and your values to help you define what your name is. So when we wanted to represent the St. Croix Valley, the Stillwater area, not necessarily be Stillwater specific, but represent that the pioneering spirit of Minnesota, just kind of that entrepreneurial, small, independent type business. And so when we were looking at things that would kind of represent that, the Lithbridge has been in Stillwater, in the St. Croix Valley since prior to Minnesota being a state. And the current Lithbridge was put up in 1938, so it's been there a long time and has been kind of a focal point of the community. And it also connects Minnesota and Wisconsin, and we hope that it kind of represents, too, that we're serving as a bridge and connecting with people in the craft beer industry, too.
Well, we're looking at a slide right now of a beautiful-looking six-pack. I think the most difficult challenge of today is going to be getting through the CLE without having a beer.
I'm already thirsty.
No, I am too. So we're looking at a beautiful six-pack of Hop Dish. How did you come up with that name, and what sort of considerations do you have when choosing to name your beers?
Yeah, so with Hop Dish in particular, being that we're from Minnesota and based here, obviously it's a play on the Minnesota cuisine of hot dish. And really what we do is we feature 7 different kinds of hops, so we combine all those beautiful ingredients. And we are actually kind of combining styles, a West Coast IPA and a Midwestern IPA, and putting those together. So you combine all those different ingredients together into just this nice, concise, one-stop shop for a great beer. Mm-hmm. So that's how we ended up starting to talk about Hop Dish. And all of our names have a story or have some kind of root in the area and kind of reflect back to our main brand as well.
Jeff, you've been working with breweries and with these issues for several years now. Let's talk about a hypothetical situation where you're approached by a client that's looking to start a brewery. And in addition to business formation issues and state and federal regulatory issues, distribution issues, you've got some intellectual property issues that are of great consideration, including starting with the name of the brewery itself and then its products or services. Given the current competition and proliferation what initial advice do you give your clients?
Well, Adam, you have to have the name protected and cleared right from the very beginning. And, it'd probably be a good discussion here to talk about the process. Everything predicates on getting a license from the Alcohol, Tobacco, Tax, and Trade Board and the TTB. You have to, in order to legally be able to make and sell beer to others, you have to have the federal license. And then you have to get your state license, but that is kind of coming. Once you have your federal license, the state falls into place, and then you go to your city and get your taproom license. But the be-all, end-all, the holy grail, so to speak, is that TTB brewer's notice. In order to do that, they want to see your ownership structure because they're going to run background checks on people that own a certain percentage. They're going to want to see your floor plan. So that means you have to have your entity formed, you have to have a lease, or you have to have property. Okay? And they want to see your source of funding. So you have to have your bank loans and your money raised and all that kind of stuff. They don't require that you have your name trademarked. Okay? But if you go through all that process and find out at the end of it that your name isn't available, you get that cease and desist letter from some other brewery out there. Now you got to go back and amend your corporate documents to change the name. Now you got to go back and refile. You have to change names with the state regulators, with the federal regulators, all those things. So when I talk to clients, sometimes it's almost we clear the name, and one day we file the business entity, and the same day or the day after, we're filing the trademark application. So we run all our clearances up before we even file anything on the corporate side to make sure that name is available, so we aren't doing things twice. That's how important it is right now in this industry to make sure that you have that name protected, at least cleared, and then moving forward with your filing soon after.
And I think we're going to be talking about some of the trademark search, trade name search efforts that we undertake. But I think you're talking about initially, do you go through that entire process? I mean, or do you, describe the process that you do?
We'll talk
to
about
clear
the search process. We will go through the searches that we're going to talk about here later on. If there's an issue with the name, sometimes we might file articles as a placeholder and then go and find out if we have, or the client. A lot of times the client will go online and take advantage of the free forms that are online and fill those out, file online, pay the fee. And so we're going to in the position of amending and restating articles. But before we do that, then Christie and you guys run the searches, clear the name, and then we go about doing all that work.
Good foreshadowing to a subject that we're going to be discussing shortly. We're talking intellectual property issues, and there may be some it may be mystical as to, we've got copyrights out there, we've got trademarks out there. Some of us see the TM superscript, sometimes we see the SM superscript, then there's patents. And I think we should just take a little bit of time, do some Trademark 101. We're going to fly through this, give you the 50,000-foot view. So you see there that there's the copyright symbol. And copyright's important, but it's not what we're really talking about today. Copyright protects original works of authorship, such as writings, music, works of art that have been tangibly expressed. While there may be a commercial about the beer or a jingle about the beer that is subject to copyright protection, we're talking today about trademarks, service marks, trade names, and trade dress. A trademark is a word, phrase, symbol, and or design that identifies and distinguishes a source of goods of one party of another party. A service mark is a word, phrase, symbol, or design that identifies or distinguishes the source of a service rather than goods. The term trademark is often used to refer to both the trademark and the service mark. And you'll see on this slide there's a name I came up with. I hope I'm not infringing on anyone's trademark with Super Cool.
We'll soon find out.
Yeah, we should find out. Maybe get a cease and desist. So the Super Cool, you'll see the TM there. we advise our clients, and clients use the TM to indicate that they are claiming ownership of that mark. However, that mark has not yet been registered. Same with Superservice SM. Superservice indicates that there are services that are being provided and that a company, Superservice, is claiming to own that name and that name to the services provided. Again, it's a service mark that has not yet been registered. The symbol with the R circle can be used for both registration of a trademark and service mark. A patent, well, we're not talking patents today, but those are concern inventions. And those also are granted by the United States Patent and Trademark Office in exchange for public disclosure of an invention. So we talked briefly about trademarks. This is a wonderful photo of the Lift Bridge Farm Girl, which is going to be subject, again, more foreshadowing. Again, just to go over this, trademark identifies the goods of a company. Service mark identifies the services of a company. Now, on this photo, it's a little bit misleading because here there's some packaging. You'll see this photo in another slide. But services are distinguished from products. Trade name. We talked a little bit about that, Jeff, in that it's the official name under which a company does business, such as a DBA or an assumed name or a fictitious name. And rights associated with doing business include the right to use a trade name for banking, for billing, for business identification purposes, and for tax purposes. The trade name itself, registering it with the Secretary of State, doesn't afford any brand name protection or provide you with unlimited rights, but it may give you some common law trademark rights. So then we get into the importance of registration of a trademark, and we'll talk about that later with Christie. Trade dress consists of all the various elements that are used to promote a product or service, such as packaging, attendant displays, product configuration. It also concerns the service that's being provided. It may be the decor and the environment that the service is provided in. For example, I always think of the distinctive decor of TGI Fridays. I don't know. I don't know if that actually is trade dress, service mark trade dress, but I always think of it that way. To receive protection, trade dress protection, the trade dress must be inherently distinctive unless it has acquired a secondary meaning. The junior use must cause a likelihood of confusion among consumers. And you're going to hear that phrase, likelihood of confusion, because that is really the hallmark and the test of trademark protection. Inherently distinctive is another phrase that's used. You just heard it. Inherently distinctive has been defined by the courts as it must be unusual and memorable, conceptually separable from the product, and likely to serve primarily as a designator of the origin of the product. I'm not going to cite case names, but if you want, I'll give it to you. Send me an email, and I'll give you some of the case names that support some of our research here today. I just said that I wasn't going to give a case name. I'm going to give a case name now because I like this case. It's 2 Pesos versus Taco Cabana. It's actually a United States Supreme Court case, 1992. And in this case, the United States Supreme Court held that a Mexican restaurant's chain decor had inherently distinctive murals, bright-colored pottery, use of specific indoor and outdoor decor with neon-colored bordered stripes, primarily pink, distinctive outdoor umbrellas, and a novel buffet style as its service. And the United States Supreme Court held that this was protectable trade dress. When I thought of this and conceptualized this, it sounded like a really kind of unsettling place to eat with its pink border stripes and distinctive umbrellas. But one other case held that and I like this case too, it's the cuff and collar design marks of the Chippendale dancers. I think we're all familiar with
no, not me. I've never heard of it.
Never heard of it. This was held to be not to be inherently distinctive back in 2010. So that's trade dress. Could use a terrible pun there, but
Right.
we're going to move away
Yes, let's.
from trade dress and Chippendale dancers and into something that may be a little bit more mundane, and that is the United States Patent and Trademark Office,
Right.
uspto.gov. And if you haven't gone there, you should go there. It's a wealth of information, but it's difficult to navigate, and we're going to turn it now over to Christie to talk about some of the issues with respect to searching and clearance of trademarks, application issues, and all of this is done at the uspto.gov.
Yeah, the uspto.gov site is interesting, and it does have a lot of information. It's also deceptively simple. And once you start the process, you realize that you're probably in over your head before you've even got to filling out the application, which can all be done online now. For example, you must select an international class for your goods or services. There's a lot of different descriptions in those international classes. If you make a mistake and register in the wrong class, you are going to suffer trying to get through the application process towards registration, and you may end up refiling, which is very expensive. There's three ways that you can, three payment levels for filing applications now. They've just brought out a new, very low one, $225 for the application, but it has very strict rules about what you can put in your application and how you file the application. The other one is $275, which is less strict and stringent, and the last one is $325, which is the old fee that has been in existence for a long time. There's a couple of things that Jeff and Adam and Tim Matson, who isn't here today, and I talk about before I embark upon the search, and that is there any possibility I can use this mark? I mean, sometimes we look at a mark that a client wants to use, and we can just tell by looking at it that it's not going to fly. There's something wrong. Because marks have to be fanciful, like Exxon, completely invented, arbitrary, Apple, completely arbitrary, suggestive, Netscape is suggestive, and logo marks must be distinctive. So when you're selecting a mark, you want to have the strongest possible mark that represents your business. Weak marks are marks that use words that are in numerous marks for the similar goods and services. Not that that mark wouldn't eventually become registered, but it's a weak mark. You can't prevent others from coming close to you, and there's already a ton of those marks in the marketplace. So you don't want to go there, and you don't want to go to descriptive marks like beef and brew for a restaurant. Very descriptive, not going to fly with the examining attorney. And certain marks that used to be trademarks are now generic. Aspirin, thermos, trampoline, these are generic now. And more recently we've got app and touch tone, which have become generic. So Jeff or Adam or Tim will come to me and say, here's the marks that the client wants. Let's see what we're going to do. And I will do a preliminary search. I will look at what's in the trademark office records, and I will look on the web, just do Google searches, and also in the Canadian trademark and intellectual property office records too. You have to be very careful when you're doing this, because the devil is in the details. The considerations at the USPTO will be sound-alikes, foreign language equivalents. So I've gotten pretty good at spotting where I'm going to go to look for potential conflicting marks in any application process. We will then analyze this information that I've gathered, and we'll decide with the client whether they want to go ahead and do a full Thompson CompuMark search, which is pretty copious. It's not bulletproof, but it's pretty copious. And then we will analyze that, and the attorney will write an opinion that will then be discussed with the client. Now we've got to the point where we have to decide what the risks are. And of course, risks are business risks. Everybody takes risks in business. But what we've tried to do here is eliminate as many of them as we can before we go ahead and file an application. Applications are made on a in use, meaning you're already using the mark. You can prove you're using the mark, and you're using the mark in the classes of goods and services in which you are registering or applying to register the mark. Or you can register on an intent to use basis, which means you're declaring that you wish to put a placeholder on this mark, and you will have up to 3 years in extensions of time, 6-month extensions of time, in which to file a statement of use, proving that you are now using the mark. You have to file specimens. These specimens must be accurate, they must be acceptable, they must be in the right format, and they must show the mark in use with the goods and services in the acceptable way that the examining attorney wants you to submit that documentation. It's a little arbitrary. I've found of late that examining attorneys at the USPTO have become much swifter in their responses and much less picky in some of their responses. But there's still, it's still an issues that you have to get over. So it's very careful. We very carefully prepare the application to avoid being stuck somewhere. And the examining attorney will then take 2 to 3 months, it's becoming actually more like 2 months now, to review your application and decide if there's any response that they want to give. And a response could be in the form of an office action. Office actions can be very serious or really, you know, no big deal. No big deal is asking to disclaim the word brewing company. And so nowadays you can actually call them up and say, yeah, we disclaim it, and they'll do an examiner's amendment. Or an unacceptable specimen, so you call them up and you'll resubmit a specimen that fits. The worst kind of office action to get is the conflicting, that they are claiming that your mark, your proposed mark conflicts with an existing mark that has prior use. And maybe, Adam, you'd like to talk a bit about prior use and what that does for mark holders.
Yes. Well, I'm just going to change the slide here with respect to trademark rights. And we're going to move this along so we can make sure we get through all of our cases, cases of beer. So prior use, there are benefits to registering the mark, but there are also common law rights to a mark. And prior use establishes your rights under common law to that name. Registration is not required to establish trademark rights. Common law rights arise from the actual use of the mark without federal registration. Its first use, it gets the first right to it. We strongly advise that if you're using a mark that you want to claim ownership of, to use the TM symbol, to at least hold yourself out there as claiming ownership of a certain mark. Now, it's very important to understand that while prior use or first use may establish common law rights to that mark, you're only entitled to those rights within the specific territory in which you're actually using the mark.
And for the goods, only for those goods.
And only for those goods. That's exactly right. So we strongly encourage our clients to register their trademarks, if at all possible. We understand that there's a cost in doing so, and sometimes the cost can be, it can be expensive. But what's the saying? An ounce of prevention is worth a pound of cure. I commonly say, I'd rather keep my clients out of trouble than get them out of trouble, because that's when it can get really expensive. When you're hit with a cease and desist letter from another company for infringing on their mark, it can not only cost legal fees in responding to the cease and desist letter, or hopefully, staying out of litigation, but then you've got to do the whole rebrand as well. So there are benefits to registration. Those benefits are numerous. One, it discourages others from using similar marks. It also protects against the registration of confusingly similar marks. Registration treats the mark as if it's used nationwide as opposed to in a specific territory. It provides nationwide notice of ownership of the mark as of the registration date, which prevents others from claiming that the mark is theirs and claiming it in good faith. It grants you the right to sue in federal court, and in certain cases you may be entitled, if your trademark is registered, to treble damages and attorney's fees. And it may entitle you to significant monetary damages in those cases. There's also statutory damages available for counterfeiting, and those may be in addition to, and there's no need to prove actual damage to receive a monetary award for claims involving counterfeiting. The registration serves as evidence of presumption of ownership. It grants you the right to use the R circle symbol, which also provides maybe an intangible benefit such as credibility to your brand. And then it also provides a basis for foreign registration and facilitating the protection of your marks around the globe. And as we know, the world is shrinking, so the proliferation of marks is becoming a major issue. So that's the benefit of registering the marks. We talked about territory and how that's important. One thing that I think we should talk about quickly is the protection of your mark. You'll see here that I think we've lovingly called this brand man. It's a parody. I think we all get it. There is no such thing as the trademark police. And protecting a trademark is very important. The best offense is usually a good defense. And Christie talked about the importance of choosing a strong mark in connection with your brand. Christie mentioned terms such as fanciful or arbitrary. I think we would all agree that we encourage our clients to use fanciful terms. Fanciful is a made-up term, and I think Christie used Exxon as an example.
Yeah.
Another example would be Xerox or Kodak. Arbitrary means that it may be a common word, but it has no relation to the good or services, like Christie, I think, mentioned Apple computers.
Right.
Apple has no relation to computers. We all now associate Apple with computers, but it's a arbitrary mark. I would argue that Liftbridge is an arbitrary mark, although it may have some significance with respect to the geographic location. It's arbitrary with respect to the beer itself.
Liftbridge have wonderfully arbitrary marks. Biscotti, which is a great mark for a beer because it says nothing about beer. And Silhouette, Scenic River, it says absolutely nothing about beer. So those are two examples of great examples of fanciful marks.
Now, you're not going to get trademark protection more than likely if you use descriptive marks or otherwise generic terms. Descriptive conveys a quality or characteristic, and we're talking about beer and whiskey. For example, extra pale ale, not going to get protection for that. Hoppy beer, not going to get protection for that. Generic would be beer or whiskey or stout. Those are generic terms. You're not going to get trademark protection. So I think Christie had a nice segue into some of the fanciful marks that you use, Dan, in naming your beers. Going back to, again, how do you come up with the names of these beers? Are you working with designers, or is it kind of a think tank that you throw names around, and then do you consult with us, or how does that process work?
Yeah, we mainly brainstorm around kind of what the style is, and again, going back to our value and our mission and who we are as a brand, and see what kind of fits there. And typically we'll create a list of potential brand names, and then we'll do some initial searching ourselves, using even just as simple as Google to see, hey, is that name out there? And maybe it is, and then we can quickly cross that off the list and not spend too much time on that name, or go to sites that may be in your trade. So, for example, we'll go to Beer Advocate or Rate Beer, which are both great websites for beer, and look to see, are there other beer names out there? Are they currently being used? Those types of things. So that helps us get a jump start, and typically we'll try to have at least 3 solid names that based on our preliminary searches are not in use someplace before we turn that over and work with Lohman Abdo to continue down the process of registering that mark.
Looking at our brand man and continuing with the protection of marks, do you have any advice, Jeff, as far as to our clients and potential clients out there as to what companies should do in addition to registering their marks, as to protecting their brand?
Well, again, monitoring it, Google alerts, those kinds of things to be able to find out if there's any similar products coming out there that might be potential infringement. And this is one of the things we come up with when we discuss about the name of a brewery or a beer. In terms, Christie mentioned the term weak mark. You mentioned weak mark. You don't want to pick something that, even though you might be able to get it, that you spend all your time trying to police it, because, like you said, there are no trademark police. You have to police yourself. And as we'll get into when we get into some of the cases, in the social media era, in this particular industry, you have to be very careful in terms of how you police those marks, because you can end up with a boomerang effect. So you want to find a good, strong mark that you can protect and that you can stand behind, that you can be confident that if you do have to send out the inevitable cease and desist letter, that you're going to have a leg to stand on.
One thing that is important, in addition to what Jeff and Dan have described, is important to realize that trademarks, you got to use it or you lose it.
Use it or lose it.
And there's the policing of the marks, and that includes not only doing the searches, but when you are aware of an infringer, you have to enforce your mark. And usually that's done with a cease and desist letter, and hopefully not litigation. But there's a reason for litigation, and that is if you don't enforce your mark, if you don't if you don't use it and don't protect it, you're going to lose the protection of it. And that's some of the undertones of some of the cases that we'll see, is the fear of losing the trademark protection. One thing I'd like to discuss is, in the world of copyrights that we live in, and trademarks, it's a nice compare and contrast of the difference between the two. And unlike copyrights, which protect marketplace of expressive ideas, trademarks deal with the marketplace of goods and services. Trademarks protect consumers from being misled. Copyrights exist from the moment of creation. Trademarks are not born, they are earned. And we're talking about not only the use and first use, but protection. And they come into existence through their actual use, developed over time, but they may be extinguished if you don't protect them. Copyrights can grow old and can die and fall into the public domain, but trademarks can continue indefinitely. And so long as there's actual and continual use, a trademark's not going to lose its significance unless it becomes...
Can I jump in there for a second? And just to remind people that you have to take action to maintain your trademark. You don't just get the registration certificate, put it on the wall or in a drawer, and forget about it. Between the 5th and 6th year of its initial 10-year registration, you have a great opportunity. First of all, you have to file a Section 8 declaration, which says you're still using the mark, and you have to prove that. But at the same time, there's something called a Section 15 declaration, and that is you can acquire incontestability for your mark because you have been in continuous use, it has acquired its distinctiveness, and now you can have that valuable declaration with your mark. That must be done between the 5th and 6th year, and then every 10 years you must file a Section 8 and a Section 9, and that those two declarations, Section 8 and Section 9, require specimens proving once again that you are using the mark in with the goods that you have in your registration, not with anything else, and you have to keep doing that every 10 years. So there's maintenance issues as well as the ongoing protection issues. You can hire services to give you trademark warnings. I think Thomson CompuMark also provides a watch service if you want to engage in that and pay for that.
And we also track the marks of all of our clients and have a calendar of due
Way
dates.
out.
Right.
I'll be on a beach with a nice a glass of beer by the time some of them come around.
You know, Adam, one more point on the
Yeah.
use. You talk about use. We're talking about use in commerce. So we've done searches for clients in this industry, and we may come upon a beer that has a similar name.
Yeah.
And we clear it because it's somebody who, it's a home brewer, and they're just promoting some competition they want or something. It's not a beer that they're using in commerce. You know, so you have to. You're talking when we do these, when we look for, you know, possible conflicts. You have to be clear about that to make sure that it's someone who's using it in commerce.
It's a good point.
And then you do have before you receive your registration or your notice of allowance, if you're registering on an intent to use basis, there is a 30-day publication period where the USPTO publishes your intended mark and the intended registration in the Gazette, and that during that 30-day period, anyone can oppose who believes they have been, you know, it's in conflict with their mark, or there's some kind of fraud or something wrong going on with your application for registration. They oppose, and that goes to the Trademark Trials and Appeals Board, and an action is your registration application is suspended, and then it goes to the TTAB for that very long process. And I think that an opposer has, I believe, up to a year with extensions for a good reason in which to file the full complaint. And so that can really stall. Fortunately, we have not had, and probably because we do so much upfront work, we have not had one of our clients' trademarks go into an opposition period.
I think you've done a nice job anticipating this next slide, which is one of my favorites. It's a little bit of a misnomer as to where to party, where to have this protection party. You'll see in cases, in some of the materials that were included for today's webcast, references to parties trying to amicably resolve their disputes before they go down a certain path of litigation. You read the news reports, you read the cases, and again, there's always some sort of effort to amicably resolve the dispute. And we strongly advise our clients and others to do so because it's not only the path of maybe least resistance, but the least expensive path. Christie did a nice job of talking about a response to an office action. And we're going to talk a little bit about that with respect to the Liftbridge Commander issue, which is a lengthy story in and of itself. The opposition to an application, as Christie just mentioned, those who hold a mark can review, see when others are registering a mark, and file an opposition to that. And just generally, is that done, again, through the website? And
Yep.
how long does that process generally take?
Well, you can file your opposition as soon as the publication period opens up. Now that then it's immediately shoveled to the TTAB, the Trademark Trials and Appeals Board, and then they will send you a notice that you've been opposed, and that there's certain periods of time in which your opposer will file a brief, you will file a response, your opposer can extend the time in which to prepare those briefs, and it can be up to a year. So it's a long process once you've had an opposition filed against you, unless, of course, your response to the TTAB feels that the brief filed by your opposer is frivolous. Your response is very reasonable and acceptable.
So I think the point is there are numerous venues, numerous avenues that someone holding a mark can protect their mark, can enforce their mark. They've got multiple opportunities, both privately and through the Trademark Trial and Appeal Board, and also in the courts. This slide's a little bit misleading about the exclusive jurisdictions of U.S. courts. It's not true. Trademarks can be heard in state court as well. In fact, there are state statutes with respect to the protection of trademarks here in Minnesota and around the country. But let's keep this moving along and discuss some real cases of beer, cases that our firm has handled and that actually concern Lethbridge. And one of the cases is actually not a court case, but it is the protection, or at least the application for and registration of the Commander beer, which is a mark that has been registered by Lethbridge. And maybe with a little bit of background, Jeff and Dan, you can take that away.
Well, I think to set the stage for this, I think, Dan, it would be a good idea to describe what Commander is, because I think that's key to the issues that we encountered with the Trademark Office.
Sure. So one of the interesting things about this beer style is it's known as a barley wine. And what a barley wine is, a beer brewed to wine strength. So it's somewhat of a misnomer. Some people think it's brewed with grapes or somehow is a wine of some type. And so I think that's where some of the confusion came in. Commander, for us, represents a building in downtown Stillwater. It used to be the Commander Company and a grain elevator, and this is a really big beer for us, about 13% by volume and alcohol, and this is a big towering building, and so it seemed like a good representation for us there. So we decided to file that mark. We have been brewing that beer since 2009, and so it's been in use for some time. And then I guess I can turn it over to Jeff a little bit about what happened once we went forward with the filing of the trademark.
Yeah. What happened is, we talked earlier about the fact that the PTO lumps all alcohol marks together. Alcohol is alcohol is alcohol in their mind. And we ran right into that. And part of this, I think, it's no different than sometimes if you're a litigator, you talk about getting the right judge. With a trademark application, sometimes it's about getting assigned to the right examining attorney. And this mark, with the name, the style of beer, with barley wine being in there, and the fact that there was a wine that was out in the marketplace that was called Commandante. And that formed the basis for the examining attorney's objection to our application for registration, and then, and then we had our opportunity to respond.
In fact, the mark Commandante hadn't actually finished its registration process. It was still in the middle of it. It wasn't a registered mark when the examining attorney first cited it, and so put us into suspension pending whether it would register. And then, of course, it did register, and so we were now in a fight.
We've talked about examining attorneys, and just real quick, who are the examining attorneys? I mean,
they're a race of space beings who came down to Earth.
yeah.
Some of them are just now so incredibly wonderful to deal with, as opposed to when I first started to do this, and they seemed very forbidding and stern people who, and of course we were doing things backwards and forwards in writing at that point. You could only submit things, in PDF form or in letter form, and so it was a faceless person. Now we have this whole new regime at the USPTO that are shoveling things through quicker, and the examining attorneys are much more open to having a phone call.
Right.
I think there's still some of the space aliens in there, but most of them are much younger and fresher and better to deal with.
But it's interesting. I believe there are hundreds of examining attorneys on staff.
Hundreds and hundreds.
And
yes.
whether your mark, the office action or office response to an application may depend upon which examining attorney you get.
Yeah.
And then the success of pushing the mark through may also depend upon that, as well as Christie mentioned, now the openness to a phone call and talking things through as opposed to just responding in writing. But the responses in writing can be quite lengthy, and it takes, I think, some skill and not only legal analysis, but to know what the issues are and how to address them through case law. And the commander versus commandante, this is before my time at Loma Abdo, and I've had fun learning about this issue and reading the correspondence between the examining attorney and our office in response. So if you recall, Jeff, and not to put you on the spot, but do you recall exactly why Commander was initially not permitted to be registered as a mark?
Like you said, I know enough of these areas to be dangerous. So it was someone else. I think it was Tim in our firm that actually handled it. But I believe that the objection originally, and I could be wrong, but I believe the objection was over this commandante, this mark that was about to be registered for wine. And now that doesn't, just the fact that we had, I think it made it a tougher issue because the style of beer also had wine in the name of it. But that wouldn't be, we'd have this issue if there was a wine out there that was about to register or was registered that had a same or similar name. You still have the same issue because of this policy of treating, the beer marks, the wine marks, the distilled spirits marks all together. So we would have this problem no matter what because of the similar name with a wine. That was the basis of their objection.
Right. And the slide that we have up here shows the filing history and basically the saga, if you will, of getting eventually Commander registered as a mark, where it started off in November of 2012, ultimately ending with the registration certificate in February of 2014. I don't know, Dan, if you've got any comments about this process and your view of it, that you'd like to share from your perspective before we get into some of the legal issues that were addressed.
Well, I mean, I think one of the things from my perspective is I feel like if we would have gone after this trademark perhaps a few years earlier, we might have even avoided this whole thing. So, from a brand owner perspective, probably filing at the earliest point in which you can is always a good idea, even if you have prior use.
But we should mention, though, that we didn't represent you guys up until about the time that this was coming up. And we have since, anytime we have a new beer coming out, we do expeditiously get a filing in. So just a disclaimer there.
And so I think, the other thing is it is a process. So it's not like takes up a ton of your time or that we spent a year and a half of constant activity. It's more of preparing a response, sending that in, and waiting for communication back. So it was a pretty easy process for us to do working with you guys.
Well, if you'll see in the materials, we included the office action by the USPTO examining attorney, and then our response, which is a very lengthy response in reaction to a couple of the arguments that were made. The one that I think we should focus on, and again, we'll get through this as quickly as possible because there's some other exciting cases to discuss, is, again, this all centers on similarity of confusion. And examining attorneys love to talk about the similarity of confusion. In this case, the confusion between Commander beer and Commandante wine. Now, just, my initial reaction to that was, I'm not seeing it at all. And our response, I think, hit on some key issues, key arguments, as to why there shouldn't be the issue of similarity of confusion.
Likelihood of confusion.
Likelihood of confusion. My mistake. The likelihood of confusion, as we said in our letter, depends upon whether the purchasing public would mistakenly assume that the applicant's good or services originate with, are sponsored by, or in some way associated with the goods sold under a cited registration or trademark. Confusion as to the source of goods must be more than possible. It must be likely. A mere possibility of confusion is insufficient for a basis of rejection under Section 2D. And again, for this analysis, we argued we're not concerned with mere theoretical possibilities of confusion, deception, or mistake, or with de minimis situations, but with the practicalities of the commercial world. We then looked at several factors under a case called DuPont, and you'll see that in our response to the office action. And there are 13 DuPont factors, and the two that we hit on as the key here was likelihood of confusion of the similarity of the mark, similarity of goods, and that the goods described in the application are different than the goods described in the cited registration. And we're talking now about beer and wine, and how in the real world there really is no confusion between the two. And again, you can read the letter and our response as to how we differentiate between those two. But then we also discussed the difference in appearance, sound, and commercial impression. And I thought this was really interesting. I don't know, not to put you on the spot, Christie, but if you may recall this part of the letter where we went through and we talked about how the words differ in appearance, commander, commandante, how they sound, et cetera, et cetera. I don't know if you've got some comments on that analysis.
Well, I think that what we relied upon also in our search for our preliminary searches for commander was the fact that we went through the most complex level of searching the website, which is a very free-form level of search. And none of this came up because it wasn't an issue. And this list of actual registrations indicated to us that there was obviously no comparison between beer and wine, because they had allowed all of these registrations with very similar names, and nobody seemed to be confused out there.
Right, and you'll see on these slides, we actually listed out in our letter how the office had allowed registrations of identical or very similar marks for beer and wine. And we've just, we've excerpted a couple of slides comparing the beer with the wine names. And we'll go to the second slide, and you'll see how the office has, in fact, allowed the registration of identical marks for beer and wine. And I thought that was also very persuasive in our response.
You know, Adam, one other point about the Commander beer that we were trying to get the mark for. You know, as Dan described, it's a barley wine. If you saw that picture in the slide, it's a 750 milliliter bottle that it has the nice packaging at the top. It's
We'll go
different
back to
than,
it.
you're not talking about a bottle that you'd find in a six-pack. And so I think that added to the examining attorneys, but maybe some of their objections to it initially is it threw them.
At
Yeah.
first glance, they could look somewhat similar, I guess.
Right. But eventually, we carried the day.
Yep.
And this, again, shows comparison, side-by-side comparison of the beer and the wine. All right, so real quick, lessons learned from that situation.
Lessons learned is when we advise clients these days, when Christie runs the preliminary searches, when we have the Thompson CompuMark search, when these marks come up that are wine or whiskey or vodka, since this mark was issued, the PTO has dug in their heels even
Yeah.
further on this whole alcohol is alcohol is alcohol.
Yeah.
And as a result, we have advised clients in the early stage to find a different name for a brewery or a beer
Yeah.
to avoid having this fight. We have brewery clients right now that have chosen maybe they were on their second or third name choice because we don't. This was an issue where Commander had already acquired a significance in the marketplace. It was a popular seasonal brand. Dan and his partners decided it was worth the fight, worth the expense to go after it and secure the mark. When you're talking about a startup brewery that hasn't opened for business yet, that calculation becomes different. And so we advise them, find a different name, stay away from the fight.
Yeah.
And Dan, just to recap, any lessons learned that you're applying going forward from this situation?
Well, certainly filing as soon as you can. I would also recommend enlisting some legal help as well. You may think it's easy enough to just fill out an online form and complete the registration yourself, but you may be missing some fine details that may cost you a lot more in the end.
Christie, any comments before we move on?
No, I think we all learned our lessons.
Good. Well, it was good that we carried the day. Commander is out there, and it's I'm going to have a commander after this panel. So we're moving on now to other cases of beer and common claims that are associated in actual litigation or maybe asserted in a cease and desist letter. And don't want to get into the nitty-gritty of the law. You'll see in the case materials that we included in this for this webcast, we included actual copies of the actual complaints that have been filed. And these complaints may be oppositions as well to trademark registration. But let's talk a little bit, just a little bit, about what these claims are. And we've got trademark infringement under 15 U.S.C. Section 1114. And this concerns the Lanham Act, which is codified at 15 U.S.C. Sections 1051 et sequitur, and enacted in 1946 based on the power granted to Congress under the Commerce Clause. It provides a national system for trademark registration and protects federally registered marks and owners against use of similar marks that are likely to result in consumer confusion or dilution of a famous mark, which is also likely to occur if there are conflicting marks out there. Federal law is independent of and concurrent with state trademark law. So there's federal law protecting trademarks, there's state law protecting trademarks, there's common law protecting trademarks. Section 1114 concerns registered marks, and Section 1125A concerns false designations of origin and protects unregistered marks. In both instances, the plaintiff must demonstrate a valid and protectable mark, ownership of the mark, and the defendant's use of the mark to identify goods and services causes the likelihood of confusion. Again, that's the test. Federal dilution of trademark. This is 15 U.S.C. Section 1125C. Take a look at that section. It discusses dilution by blurring and dilution by tarnishment. And it doesn't involve alcohol use, but dilution by blurring, I think we've all experienced that maybe after 2 a.m., kind of leaving a bar or a saloon. Common law trademark infringement. Trademark is protected by statute and common law, as we mentioned. In Minnesota, Section 333 covers trademarks and service marks, and the court set forth a multifaceted or multifactored analysis for likelihood of confusion. Section 333.28 concerns trademark infringement. 333.29 discusses the type of remedies that are available under the Minnesota statute, and this includes injunctive relief, monetary damages, treble damages, and attorney's fees if the infringement was with knowledge or bad faith or otherwise, I love this, or otherwise as according to the circumstances of the case, whatever that means. Unfair competition, deceptive trade practices. This under Minnesota law is Minnesota statute 325D.43 and 325D.44, deceptive trade practices. That protects goods and services, so you can't pass those off as goods and services of another. Likelihood of confusion is the source of affiliation, and that the goods are represented of a particular quality standard or grade. And the remedies for those violations are at Section 325D.45, and that's injunctive relief and attorney's fees. So that's some law for you. Let's move on to, again, actual cases where some of these claims have been asserted. We're here with Dan. He's had some experience with this with our firm, and this is the case, Lithbridge versus Lucet Brewing. Take it away.
Well, I would say, and I'll defer to Dan here in a minute to give some of the background as to the communications that led up to this, but I would say that this was probably the first trademark case that came out in the craft beer era here in Minnesota. It was probably the most the highest profile. There's been one since then, the Bent Paddle, we'll talk about in a minute, but this one was the first one. And the interesting thing about this one, we talked before about how you can have the online backlash, and some of these larger cases that nationally have had a greater online backlash through social media. This one largely did not. Dan, why don't you talk a little bit about the Farm Girl beer, because that's kind of key to this whole thing.
Sure. So Farm Girl Saison is our flagship brand, so it's our most popular beer, and it's pretty pervasive throughout the Twin Cities, the state of Minnesota, and actually into western Wisconsin. The beer, we've actually had that as a registered trademark. We filed for it in 2008, prior to us actually brewing the beer. So that was one of the earliest ones we did. And we had a new brewery called Lucet in western Wisconsin start up, and they started brewing a beer called Farmer's Daughter. So even though they're not exactly the same, they do share some imagery. They also share some words or pieces of words, and so what we started seeing is some confusion in the market from consumers saying, I had Lucet Farm Girl or Lithbridge Farmer's Daughter in social media posts. We've even had customers accidentally order with mixing up the names back and forth. And so we actually had a phone conversation with Lucet about our concerns and to ask their help that we work together. And the initial response was that they felt that there was no confusion or no possibility of confusion. And so we tried to work with them directly, and I think that was a good approach to start off with. Later on, we had who we think one of their wholesalers print a sign when they launched in a new market in central Minnesota, actually using our mark. So it said a new beer, Farm Girl, from Lucet Brewing. And so we did send a cease and desist letter specific with that poster, and we're met with. Basically, they were denying that was an issue, or that inferring that it may have been us who actually planted the poster. So at that point, we felt like our only option was to really protect our mark by filing a federal trademark suit.
And so we represented Lifbridge in filing the suit. And so, long story short, it was settled. The terms of the settlement were confidential.
Can't talk
So
about it.
what we're talking about here is everything that's on the public record. It's in the court documents. The poster that's in the slide here of the farmer's daughter farm girl spiced blonde ale. That's the poster that Dan is referring to. That was we believe prepared by a wholesaler. So when you have the wholesaler, the distributor, confused over is it farmer's daughter, is it farm girl, whose is it? Now you have a serious problem. This is not a single consumer making a mistake and posting about it on a website. This is a distributor who's supposed to know these things, that has everything marked combined. And like I said before, we didn't really. There was a few people that may have kind of griped about us bringing the lawsuit, but pretty quickly public opinion turned in our favor. The consumers understood why we were doing this when this poster that was actually attached as an exhibit to the complaint was put out online from different media sites and things. Everybody was kind of like, oh, yeah, they have to do something. You have when you have actual confusion like that, you have to step in. So fortunately, it was settled. Both brands do exist today, and life goes on. But it was an interesting fight. I don't, if this poster hadn't existed, I don't know that it would have escalated to that point. Certainly, when their response came back claiming that we had fabricated the poster, that I think was kind of the straw that broke the camel's back.
So we're talking now about, unfortunately, but fortunately it got resolved, but unfortunately it went to litigation. It was filed in federal court here in Minnesota, maybe one of the first, if not high-profile craft brewery trademark infringement case, where there are multiple claims that were brought, including false designation of origin under Section 1125A, state unfair competition, trademark infringement, common law unfair competition, and violation of the Unfair Trade Practices Act, which we talked about, which is codified at Minnesota Statute Section 325D44. The second amended complaint is included in the materials. It's a really interesting read. You'll see the exhibits at the back of the complaint do demonstrate how there was some confusion in the marketplace. And for those who aren't seeing it, I mean, we've got the slide up, but looking at the slide, where actually is the confusion on this poster? For those who aren't really seeing
Sure,
it.
the confusion is the photo is of the Lucette Farmer's Daughter cans. It's the Lucette beer, and Lucette calls their Farmer's Daughter beer spiced blonde ale. Okay, Lifbridge calls theirs Farm Girl Saison. All right, so you've got the imagery of Lucette, part of the name of Lucette in terms of the style of beer, the spiced blonde ale, and the Farm Girl, which is Lifbridge's trademark, listed as the name of the beer instead of Farmer's Daughter. And that's where the confusion lie, in that the fact that they're using our trademark name instead of Farmer's Daughter on that poster.
Right. So this poster is evidence of the actual confusion that existed. In this case, a poster that was prepared by one of the distributors.
Yeah.
And I think what it demonstrated is we've gone far beyond the bar of likely confusion to actual confusion, and not just your average consumer, but somebody who's actually in the industry and should know better.
Yep.
Between the brands.
Yep.
Let's move on as we're coming down to the wire here. We're going to rifle through some more of these cases. This is the case of Long Trail versus Bent Paddle. And if you could, Jeff, maybe you discuss a little bit about the facts concerning this case.
Long Trail Brewery is a brewery located in Bridgewater Corners, Vermont. And you can see in the imagery here on the slide, for those of you looking at the slides, Long Trail Brewing Company has in their logo this hiker silhouette that's part of their logo on their cans. Bent Paddle is here from Minnesota, it's up in Duluth, and they introduced a trail series of beers, and they used their own hiker logo for this to denote their trail series of beers. Bent Paddle does not use the hiker in its logo, as you can see from the can and the slide. They have other beers, but for this series of beers, and this Day Pack Pale Ale is one of them, they have this hiker logo. And the Long Trail complaint, interestingly enough, had an allegation that there was likelihood of confusion, as they were arguing that similar, the logo was likely to confuse consumers. The interesting thing was an allegation that Bent Paddle was selling their beers in Vermont. I had just recently had talked with those folks on a different program, and they said we don't sell in Vermont. So there
Just real quick, just a point of clarification. We represented who in this case?
We didn't represent anybody. We don't represent either party in this. This is just simply another Minnesota trademark infringement case.
Yes.
The infringement case involved a Minnesota brewery.
Okay.
Yeah. So, so my information on this is all just reading the news stories and talking to the owners of the brewery one time on a radio program. But they were not distributing in Vermont, so you didn't have the same market overlap that Lithbridge and Lucette had with the Farm Girl Farmer's Daughter dispute. This was settled earlier this year, and it was an interesting settlement, and I think it was a good PR move on both their parts. Bent Paddle made a donation to the Green Mountain Club in Vermont, and Long Trail made a donation to the Superior Hiking Trail Association here in Minnesota, and that's how they settled. That's how they settled the case. And I think they had some. I'm sure they had some other agreement as to changing. If they were going to change the logo, or I don't know, whatever it is. But at least the public announcement was they were going to make this cross donation thing, and the
Good PR move.
Yeah. So so this was a similarity of a logo, and in two small breweries in different parts of the country,
Right.
and that's it.
Well, let's continue with another issue that has developed not into litigation, but they're keeping things in our backyard here in Minnesota. There's been some news reports about another trademark infringement.
Actually, Adam, I'm going to interrupt one
Yeah,
second.
go
You can
ahead.
stay on this one for just a second, because
sure.
Another interesting point about this one is that the Bent Paddle had good insurance coverage. They had an intellectual property coverage in their commercial general liability policy, and they tendered this lawsuit, the defense of this lawsuit, to their insurance carrier, who picked up the defense for an up and coming brewery, smaller size right now, like these guys. That was crucial, and so one of the things we do advise our brewery clients in this market where this trademark stuff is hot, is making sure that they have intellectual property coverage in their liability policy, so that if something does happen where they have to defend against a trademark lawsuit, they can tender it to their insurer. It could be the difference between staying open and shutting down.
A topic for future consideration, no doubt about it. Well, moving then on to another backyard dispute, and it's really not that much of a dispute. We just thought it was interesting. This is the Motion Picture Association of America versus 612 Brew, the 612 Brewery in Northeast. And I included some of the graphics here to show the original advertisement for the 612 Rated R beer, and then what it eventually became in response to the Motion Picture Association of America's cease and desist letter. And I don't know, Jeff, if you want to comment shortly on the background of this story and what happened.
612 is a brewery here in Minneapolis. I think they're approaching their 3rd anniversary, and Rated R is one of their very popular beers. And they received a cease and desist letter from the Motion Picture Association of America, and claiming that the Rated R was, was infringing on their mark. You talked earlier about, making the business decision to, in terms of protection and policing. 612 simply made a business decision that it was less expensive. It was, and their best move was to simply change the name of the beer. I know they just were in the process. They were going to come out with cans. They got the name changed before they had their cans printed up with the new artwork and the new label. So they simply went in and got approval for a different name, different label, and that's it. And so it fizzled out. They got a cease and desist, and they changed the name.
Well, it's interesting. We talk about, the PR involved in some of these disputes. And I think this next one, this is Lagunitas versus Sierra Nevada case, which was filed just this January of 2015 in the Northern District of California, one of my favorite courts. This case is really interesting. I mean, we're looking at the slide here, looking at two of the six-packs with the brands involved. And so Lagunitas files this case, and they claim that they've got this iconic use of the large, all-capital, bold, black IPA lettering in its label, its packaging, and family of trademarks. And in the complaint, you'll see, again, it's included in the materials, they claim that since 1995, upon information and belief, I always love that phrase in complaints, no other company had marketed or sold its India Pale Ale using the IPA acronym. Instead, brewers focused, and this is taken from the complaint, brewers focused brand identities around visual cues involving either sea travels or themes representative of the culture of India. So Lagunitas claims that Sierra Nevada is now making this radical departure from its traditional IPA label designs, and that this radical departure is causing the likelihood of confusion among consumers and the consumer perceived connection between Lagunitas and Sierra Nevada. So that's kind of the essence of the claim. And Lagunitas claim trademark infringement, common law infringement, unfair business practices under California law, and unjust enrichment. So this case is filed on the 12th of January of this year. And within moments of filing this, Twitter blew up. Everyone started criticizing Lagunitas. There was such incredible backlash that I think it's 2 or 3 days later, Lagunitas pulled this lawsuit in response to the PR backlash. And gentlemen, I don't know if you have any comments about a reaction to this lawsuit.
It was
going on at the time.
Fierce. I saw a lot of people commenting that they were never going to drink Lagunitas again, over this. And like I said, if it lasted a week, then that was it. But it was the shortest-lived trademark dispute amongst breweries in recent times. The owner of Lagunitas wildly misjudged what the reaction would be from this.
Right. Dan, did you follow this at all?
Yeah, it was quite interesting. It almost happened before some people even knew about it. But, I mean, I think clearly here Lagunitas made a business decision, again, after building a brand new brewery in Chicago, that we want people to keep drinking our beer, and that's not what we want to be known for, is suing other breweries.
Well, that's really unfortunate. I mean, I obviously grew up in England, and I recognize the words IPA from, opening my eyes in the crib. You know how much we love our beer. So I can't, I just don't understand the reasoning. In England, we would just go over there and give them a good thumping.
I think it's this undercurrent again of, and the next case we'll talk about really kind of set the stage for this combating litigation in the social media square. We talk about the Magic Hat West 6.
Move on to that.
This case here, but what again? There's this public relations backlash you can get if you don't. You have to have your PR message ready to explain to the beer consuming public why you're doing this. And in our case with the Liftbridge Lucette lawsuit, consumers understood that. That poster was a good visual, and they understood the reasons behind that suit.
Very clear.
The bold black letters IPA, Lagunitas didn't make its case effectively enough to the consumers as to why it was important for them to do this. With Magic Hat and West 6th, again, we're looking at two logos. The fight was between Magic Hat and West 6th was a brewery in Kentucky. Magic Hat sued West 6th, claiming that the logo was very confusingly similar to their number 9 beer, which was a flagship that was actually being was distributed throughout the U.S., but in Kentucky. And Magic Hat, West 6th, their first response was they started an online petition against Magic Hat. Mm-hmm. And it turned really ugly. This is probably, would you say, Dan, this is probably probably the highest profile national trademark case,
yeah.
and certainly one of the most contentious.
Yeah.
Because Magic Hat then turned around and filed for injunctive relief against West 6th to stop them from doing this online social media petition. Mm-hmm. They ultimately did settle this case. There were changes to the logo. You can see the West 6 obviously has the 6 and this little, they call it the dingbat design, the little star thing in the logo. That Magic Hat said that number 9 was confusingly similar, and if you rolled it upside down, then you had the number 9 and all that. So West 6 did change their logo as part of the settlement. They took off the brewing part of the name on that alongside that logo, and they removed this dingbat symbol. So Magic Hat had, felt they had a moral victory in that they did get West 6 to change the logo somewhat. But again, this one was highly contentious, and this really kind of laid the blueprint now for you not only have to have an effective litigation strategy for these cases, you also have to have a public relations strategy ready to go on the day you file, because it's going to escalate quickly in this day and age with social media.
And that may be a good place to kind of wrap this up. There are several other cases that we include in the materials, and I don't want to steal your thunder if you want to talk about any other cases. I know we're running a little bit over time, and we may have some questions from the audience out there in the web world. Talking about the PR backlash and considerations that brewers have in not only choosing their brand, but protecting their brand. One of the cases that is included in our materials is the Bells versus Innovation case. Check that one out, because it resulted in actually this. Innovation is a brewery in a small town in North Carolina, and they've got a crowdfunding source or a crowdfunding site up to help them combat this lawsuit that's been brought on by Bells. Actually, it's a suit in the appeal board, or an opposition in the appeal board. So check that out. But in wrapping this up with considerations of PR and where are we going from here, I think we've got a video that we'd like to play about craft on craft crime. It's an interesting phrase, craft on craft crime. It kind of sets some of the sentiments that are out there as to where we're going. And again, this is a video from
Sam Calagione, who is the founder and owner of Dogfish Head Brewery, which is the first brewery that was in the state of Delaware, and a very popular brewery distributed nationwide.
Okay, let's see what the message is of this video.
I'm Sam Calagione. This is Dogfish Head Brewings and Eats, our original home in Rehoboth Beach, Delaware. I'm here to talk to you about craft on craft crime. Nobody gets out of craft on craft crime alive. And there's no victors. There's only losers. And that's because our industry and its success is founded on the karma that comes with working together. From the classes that Charlie Papazian taught in Boulder to start our homebrewing movement when Carter made it legal, to the baton that was passed from Fritz at Anchor, handing his first used piece of equipment to Ken Grossman. The reason our industry has grown because we love each other and we care for each other, and we got to keep that going. Cheers.
Well, that was an interesting message. Dan, what's your reaction to that message?
I mean, I think whenever possible, certainly you should try and resolve it amicably. As Jeff mentioned, it is a very collegial place to work in, and the industry is fantastic. However, at the end of the day, we are businesses. We are trying to grow our value of our business. We also have responsibilities to our employees and our communities, and so we need to make sure that we keep that business going. And part of that may be protecting our marks.
And just a point of information, Dogfish Head has had to send out their share of cease and desist letters too, as I understand.
Yeah.
So.
Well, I think that's going to close our panel discussion for the day. Jeff, I'd like to thank you. Dan, thank you very much for coming out today and joining this panel. Christie, I'm going to meet you guys at the bar in 5 minutes, and
We'll grab some Farm Girl and Commander.
Let's do it. Thank you, everybody, for joining today. We appreciate it, and have a good rest of the afternoon.
Thank you for joining us for today's webcast. We would really appreciate it if you would click on the materials link and then fill out the course evaluation. We want to make these webcasts even better, and your input will really help. Thank you very much, and we hope to see you at future webcasts.